forward, but we explained rather so that committee members can engage with the presentation. Thank you very much, Chair. I now hand over to Mr. Ralekwa.
This application was in two parts. There was the part A, which was an urgent interdict to reinstate the salary, and part B was the overall review application to and charge Mr. Blosse. You'll see that in the judgment. I hope it was provided to members. It limits itself with regard to only part A, as I indicated. And of course, the judge made some remarks on some procedural issues, which we would not want to engage at this moment because we still go into part B, where we'll deal with such matters. But of importance is just to record that the order that was issued indicates that at paragraph 7, accordingly, I make the following order. Pending the determination of the final relief sought in part B of this application, first and or the second respondent are interdicted and restrained from withholding the applicant's salary or remuneration during the period of his provisional suspension. The cost of part A shall stand over and be determined at the hearing of part B of this application. So the court only limited itself to the remuneration part. So what we also mentioned on the 25th is that the anomaly of this application is that Parliament, unfortunately, was not cited. So this is a matter that I suppose the committee with the legal advisors may have to grapple with, as you decide on it today, as to how to proceed with it. Because I think the challenge is that even though you are not cited, if you were to, proceed with the determination of salary, whatever decision you reach, the interdict at the end of the day, the implementer is the minister. So the interdict is against the minister. So I am aware that there's a letter from the minister that is on its way to Parliament to explain this.
Mr. Finger, colleagues, any additions or you are covered? Can I see thumbs up from the department if you are covered so we can note members for engagement?
Chair, if I may come in, we are covered for now.
Okay, Samsung. All right. Covered for now.
Chair, we will take a question. The team is here to assist with. Thank you, Chair.
Oh, all right. So you are fully covered by Mr. Finger brief. So you would await members' interactions.
Yes, Chair, we will await the questions and the team will be available. Yes, thank you, Chair.
Okay, Ms. Pillay. Members, now I move for the show of hands for clarity-seeking questions and as well any comment with regards to the matter before. In terms of reducing the numbers of teenage pregnancy. So the awareness is actually acknowledged as a background in this time and era. Teenage pregnancy is one of our headaches in South Africa. I've noted your two questions of which they are relevant. That one would wanted to even seek clarity around in terms of the question that you have asked, that did the commission really ask or get sense why were we not cited? Because the decision taken and what we are engaging before, it's what has came before the select committee. So if they can give us that particular clarity, one would be happy. However, I think one of the things that Mr. Finger is indicating that we can explore is us as well getting to have a session after getting the letter that he has indicated that it's on the way to Parliament. We would need to check how we then call a meeting to have our legal advisors and Parliament advisors to deal with this matter so we can understand how we deal with these two issues. However, as you said, we'll be noting now, the matter is not about issues that were before us and misconduct and what we want to protect in terms of the fiscus of the country. Because these interdict, they are specific on what is their interest. And on our side, their interest is our interest as well in terms of protecting the public purse. But however, we cannot deliberate on that. It will be a discussion for another. On the matter that we are asking, if possible, perhaps submit a written response to us with regards to the question. If it has been asked why Parliament was not cited, and if we can get clarity. However, we note that on the matter of Mr. Mkansi, what could have transpired, and as well the overlapping or lack of not citing the NCOP in what has been put before as an interdict, it's noted. So I just want to check on your legal department if they would want to say something. If not, we can continue with our meeting and then agree that the deliberations on the update are being considered and heard, noting as well that you have given us the update on Mr. Mkansi, of which it was not a part of the matter, but we want to acknowledge your proactiveness because it shows that you have went through the agenda as sent to your good selves. Over to you. If you are fine as the department, Ms. Pillay, you can indicate that you are fine. We'll get the written submission.
Chair, may I just come in with clarity? I spoke to Mr. Ralekwa, who is also the acting head of legal services in the department, about whether we had taken, specifically whether we took the issue of a misjoinder. And I'm told that yes, we did do that. And because the Parliament must be cited as a party, and also they must seek permission to join Parliament in litigation proceedings. So that's his position. That's the update on the issue of the misjoinder, which I think is a very good point. And then on the Mkansi matter, I believe it is in court this morning. Council is on brief, and we will further update the committee in writing, and we will also be raising the issue of misjoinder where Parliament has not been cited appropriately. Thank you, Chair, and that is all from our side in terms of these matters. Thank you, Chair.
Mr. Finger or Ms. Pillay, clarity on what Honorable Nonkwanyane could have said. Yes.
Read the order as requested. I do apologize if I may have misspoke on the issue. So they are asking for order on the following terms. One, that the respondent or any other person acting under their authority or by instruction be or hereby ordered forthwith to reinstate applicant's salary and attendant benefits on the payroll of the third respondent, that's the department, pending the final determination whether administrative or judicial, of applicant's removal from judicial office and any review or appeal related thereto. And it specifically recorded that this relief is of an interim nature and is not intended to constitute a final determination of the parties' right. That the respondent are ordered to pay the costs of this application. And then number 3, the respondent must furnish applicant with written reasons for the withholding of his salary together with the outcome of his representations lodged in terms of section 13A. And 4, that it is declared that all available internal administrative remedies under the Magistrates Act and in terms of the promotion of administrative justice Act have been exhausted and are deemed to have been waived in terms of section 1.2 of the Promotion of Administrative Justice Act of 2000. And number 5, that it is ordered that the interim mandatory interdict sought herein is not intended to and shall not prejudice or conflict any of ongoing or contemplated proceedings, investigation or processes undertaken. So, Honorable Nonkwanyane, it is clear from what you're asking that what Mr. Mkansi, and I think the legal team, except also raising issue of urgency on the matter, has noted that there's no even an inclination here that they are going to apply for review, except that they are asking for reasons. So for now, we are just asking for the salary to be an interim order for the reinstatement of salary. And yet, as I've read, they are asking for reasons why we took a decision, and I don't know, perhaps on that basis then, but it is, I think the legal guys can comment on it. It would have helped to indicate that they are also asking for a review immediately, but I'll leave it to the legal people. Thank you.
Thank you, Mr. Finger, Ms. Pillay, or legal department.
Could Risha or Mr. Williams come in, please?
I see Mr. Williams doing thumbs up. Mr. Williams, just give one or two clarity-seeking information or indicate if we'll await the response as indicated by Ms. Pillay with regards to these matters. Over to you. Am I audible, members?
Yes, Chair. Clear.
So, yes. Ms. Pillay, Mr. Williams?
Yes. Could somebody from the department? Yes.
Yes, thank you very much, Chairman. My apologies. I'm just putting the video on just for a second in terms of for you to see who I am, and then I will proceed.
Yeah, I've been seeing your thumbs up. You can proceed and switch off the video.
Thank you, Chair. And my apologies again for the thumbs up. It was actually, I wanted to put my hand up, so my apologies with the Zoom. So my apologies for that. Chair, I just want to mention one or two things that, and it has been raised by some of my colleagues. But I think the issue for us in terms of I'll start with the Blosse matter. I think that is important. When it served before the Select Committee on the 25th of March, the judgment was still pending. So the judgment in that matter was only delivered, in fact, was delivered the next day, is my understanding, on the 26th of March by the judge. Now, Chair, and I think it will also be in the Minister's correspondence, I think what is important is twofold here. The one, like already been indicated by the Magistrates Commission, is that the magistrate did not take on anything regarding the provisional suspension, and that's why you will also see, and there the minister's got a discretion in terms of the provisional suspension, and she has in fact suspended him. So that still stands, and that was also the subject of the order. And then if you look at the order itself, the order was in terms of the remuneration. Now, when it comes to the withholding of the remuneration, that determination is being made by the Commission. And of course, then it must be confirmed by Parliament. So the Minister plays no role in the determination of the withholding of the remuneration. She must submit the report to Parliament, but she's got no role to play there. That determination is being made by the Commission. And how it works in practice is, in fact, once the Commission has made a determination, they actually submit that determination to the Department, and the Department of Justice must then implement that determination, and that's where they start withholding the person's remuneration. I thought I'll just explain that part in terms of the Blosse matter, Chairperson, and then I'll go over to the one on the McKenzie, if you're fine with that. Or
continue, Mr. Williams.
Thank you, Chair. That is correct. In terms of the McKenzie matter, I can just add, and I've also read his affidavit, Mr. McKenzie, and I may just mention, I did speak this morning. You will recall that in the McKenzie matter, he was in fact found guilty of a criminal offence defeating the end of justice, and we have been informed that the prosecuting authority is appealing the judgment. I think the judgment was 100,000 rand to 5 years imprisonment. And I did speak this morning to the Director of Public Prosecutions in the Free State, and she indicated to me that they in fact proceeding with the appeal against the judgment, and they are actually waiting for the transcript still. So we're trying to expedite the issue of the transcript so they can take that process forward. But I think what's also important in the McKenzie matter, and I think we should also come clean here and mention that, and again, it's the issue of the determination of the withholding of the remuneration. My understanding is the reason why Magistrate McKenzie is only bringing the application now is in terms of administrative issues, because what actually happened, his determination was not actually withheld since the Commission have made the decision. My understanding is that the determination was, because of an administrative hiccup, the determination was starting to have been withheld from now somewhere in April, and that's the reason why he brought the application, because I was also surprised that he's only bringing the application now. So I have been informed that in fact is the reason why he's bringing the application now, and I thought I'll just put that up front, that the honourable members are all aware of the situation, Chairperson. Thank you.
Thank you, Mr. Williams. We want to acknowledge your clarity, and as legislators, at least we are learning as we do our work, that there's a ecosystem of some sort of dealing with legal things that like this, as it is being subjected to get to a legal process. And we're noting as well that at least flaws were identified, and we would continue engaging and make follow-up with regards to what has been presented before us in terms of the 9 joiner. However, one would want to say that with regards to these matters as well, at least we are giving you 7 days to 14 days to submit. The issue of Kanzi is in court today. Perhaps maybe after today, Mr. Finger, we will get the communication from your good selves. We have no as well that there's a letter coming so we can get where we are in terms of yes.
Apologies, you just about 30 seconds you broke, your connection broke there.
Am I audible?
You're audible now.
Yeah, you are back now.
No,
the secretary is correct. You are back now.
I'm in the booth, as I said, so the connectivity it holds and then lives as it wants to. So I was just saying that we still stand on the matter that perhaps let's get a written submission with regards to these 2 matters. However, we are noting the status quo before us, and we are learning as well with regards to what has actually been noted by Honorable Nonkonyane in terms of the 9 joiner of how these interdicts were processed, and the limitation of Parliament not be cited. And we just want to say that let's get updates after today's case as well, after today's attendance in court on where we are with regards to the matter of Mikanzi. However, would as well as I indicated that we'll call our legal advisors to interrogate these matters after that submission of the letter that Mr. Finger could have said that it's on its way to Parliament, and as well with what we are dealing with today. So with meaning that the matters that are before us have been exhausted and members have clarity with regards to these issues. And I'm happy that in our collective we do have an advocate who was able to even ask on limitation or on things that we thought that maybe they were not explored when the interdict was submitted. With that being said, I want to acknowledge the fact that as we do this work, we are noting the progress made, or the progress that is being achieved by the Magistrate Commission from where we are to date. And we want to appreciate that at least when we meet with your good selves, we do have a ticking box of success and achievement as a department with regards to matters of magistracy and the judiciary, the judges. So we really appreciate your commitment in ensuring that we get to our zero backlog of issues that we feel that they impede us being seen as a good department, or the commission being seen as the commission that has people who are fit for purpose. We want to thank you, and you can be released with 1 or 2 closing remarks, Ms. Pillay. So we release you, as members will be dealing with minutes of these items before us. Over to you, Ms. Pillay.
Thank you, Chairperson, and I thank the committee for the time today and for listening to these matters. And Chairperson, we will await, we will provide updates on the litigation matters, and we will await to hear from the committee on the rules that we presented earlier on. Thank you very much, Chair.
Okay, thank you, Ms. Pillay. You are duly released. Now we are dealing with issues that only needs members to deliberate on.
Okay. Thank you, Chair. Thank you.
Thank you, Ms. Pillay. Thank you, honorable members. Thank you. Now we are on the item that deals with committee considerations of reports. I know that we have got these reports before time, and it's just very soon that we were dealing with these matters. So I just want to consider all these reports at once. Report on removal from office of Ms. M. Maitufi, additional magistrate at Garankua, and for the withholding of remuneration, which is A. B. Report on the removal from office of Mr. L. Chimkanzi, and for the withholding of remuneration. And then C. You can't hear me, and I'm on this side, so I don't know what could.
No, we can hear you.
So
You've been fading, but we can hear you.
I was off. Okay. So members, I was just going through the items that are before us, from item A, B, C to item C, I, C2, C3, where we have we are dealing with the reports. And as I said, I want to indicate to you, would want us to adopt them simultaneously because we got them prior to this particular meeting. Noting that in terms of a report of Nkansi, we got some update that will go on the item of the update that we were dealing with Mr. Blosse. So I want to note hence from members with regards to adopting and seconding these reports as tabled. I see there's a hand. I'm not sure. Cash?
Yes, Chair. Just quickly, Chair, I just wanted to confirm for the committee, Chair. So in the Maitufi matter, we'll be dealing with the removal and withholding, those two items in the one report. And then with the Mukansi matter, we'll only be able to deal with the removal matter. The withholding we can separate from the report because it's a second matter, and we can deal with it after the department has submitted those letters, Chair. And then the last one is just the resignations, as you mentioned, Chair. Thank you.
Okay. No, thank you. I think your input is in order. Hence, I was saying that the other matter with regards to the update of Nkansi must be added on the update information as we got this information in this particular meeting. So what you said, it's in order, and members would take note that on this one of Nkansi, we are only dealing with the removal, not the withholding of the remuneration. So as I said, members, I would want to note a hands that adopt and a hands that second all these reports simultaneously. Over to you. Honorable Nicholas COGTA.
Good morning, Chair, and good morning to all the colleagues. Chair, I move to adopt all those reports in line with how it was explained to us now.
Okay. Thank you, Honorable COGTA, for your commitment. I'm not sure if you are in the country or you are somewhere. Honorable Ofe.
Thank you, Chair. I second the move by Honorable COGTA. Thank you.
Thank you, Honorable COGTA and Honorable Offense, for duly adopting and seconding the report simultaneously, and noting as well the amendments that will be made in our report of today's meeting. With that being said, members, I want to end in ensuring that our Peace and Security Justice Select Committee is responding to issues that we think that they've been pending for long, and in our time we seek not to overlap our work's progress and reflections of the impact that we would want to see in the lives of our people. As we always say, magistrate and who are in the judiciary, justice delayed is justice denied. And in this platform as well, in these matters that we have dealt with, the sooner the better. Matters are being dealt with and handled with care without misrepresenting the Constitution in terms of the Bill of Rights. One would want to thank you, honorable members, for your maximum participation, and as well the stewardship by our whip today on issues that were before us, because issues that we're dealing with, advocate minor issues, it's issues that you would need to process them legally so that you don't find yourselves under the bus, but being on top of the issues without infringing on other people's rights. We want to thank you, Honorable Nonkonyane, for your stewardship and the collective, our support staff, content advisor, and those who have made sure that today's meeting becomes a success, even though we know that other members are committed somewhere. The meeting stand agenda. I thank you, and all the best to those who will be debating on today's debate in the House. I thank you.
Thank you,
Thank you,
Chairperson.
Chair.
Thank you, Chair. Thank you, Chair.
Tango. Ngiyayithanda le picture le.
Nkosi.